When you start a lawsuit for medical malpractice, and now you serve the lawsuit papers on the doctor whom you are suing, why does his attorney always, invariably always, deny each and every one of your allegations? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. You believe that your doctor was careless, causing you significant harm and injury. And now you decide that you want to bring a lawsuit against your doctor. After a medical expert has reviewed all of your records and confirms, yes, there was wrongdoing, and he confirms, yes, that wrongdoing was a cause of your injury, and yes, your injuries are significant and permanent, now, only then, are we permitted to go ahead and file a lawsuit on your behalf. Okay, so now your attorney prepares a document called a complaint. And now, that starts the lawsuit. We purchase an identifying number in court called an index number. And now what happens? And now we have to take that document and actually deliver it to the person that you are suing. So now the doctor gets those papers, he sends it off to his insurance company, who then hires an attorney. And guess what? The defense attorney actually answers the allegations in your complaint. And now, as they go through the complaint, they go, deny, I deny, I deny, 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 deny. Why would they do that? They do that because if they turn around and admit that certain things were done incorrectly, if they turn around and admit that the doctor was careless or that his carelessness was a cause of your injury, now we have short-circuited the entire lawsuit process. So typically we have to show, number one, there was liability, that the doctor violated the basic standards of medical care. If the doctor has admitted that and acknowledged that yes, he was careless, guess what? Now we only have to evaluate and decide the following two items, which is, was the doctor's carelessness a cause of your injury? And if by some chance the doctor were to admit that, now the only thing left to decide is how much money you are to receive for all of the harms and losses and damages that you incurred. But guess what? That doesn't happen. Instead, the defense attorney denies every single allegation that you have raised. And now when we tell you that we have received the answer from the defense attorney and that he denies all of the allegations, you are going to be upset. You are going to be furious. You are going to think to yourself, how could they possibly deny and refuse to take responsibility for all of these things that happened to you? How could they do that? Well, you should know this is a legal strategy. Things may change down the road. This forms the basis of the entire lawsuit. So here are your allegations. Here are the responses to those allegations. Now, put the two together and you have what's called an issue. You have significant issues that now have to be resolved, either voluntarily amongst the parties or at trial. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand and I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but have not yet done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.